Decision podcasts by the New York Prosecutors Training Institute are made possible by VoicePods. Convert your text to voice at voicepods.com. Read this decision at NYPT Law. www.nypti.org/law.
People v. Manragh, decided November 20, 2018. Memorandum. The order of the appellate division should be affirmed. Defendant, who pled guilty, claims his guilty plea was entered involuntarily and the indictment must be dismissed because the prosecutor failed to notify the grand jury of his request to call a particular witness, and failed to allow the grand jury to vote whether to hear that witness, in violation of Criminal Procedure Law Section 190.50(6). Defendant does not contend that the evidence before the grand jury was insufficient to support the indictment. Instead, defendant claims that the prosecutor's conduct impaired the integrity of the grand jury proceeding and argues his motion to dismiss the indictment for defective grand jury proceedings on that ground is not forfeited by his guilty plea. The appellate division held that defendant's plea was entered voluntarily, knowingly, and intelligently, and that, by pleading guilty, the defendant forfeited his contention that his motion to dismiss the indictment should have been granted. We granted leave to appeal, and now affirm. On review of the record as a whole, we agree that defendant entered his guilty plea understandingly and voluntarily, People v. Harris, and that the county court did not improvidently exercise its discretion in refusing to allow defendant to withdraw his plea, Criminal Procedure Law Section 220.60(3). Nonetheless, we have explained that even after entering a valid guilty plea, a defendant may not forfeit a claim of a constitutional defect implicating the integrity of the process, People v. Hansen, and we have recognized that certain claimed defects in a grand jury proceeding rise to this level, e.g. Hansen, claims implicating the constitutional function of the grand jury to indict, or the prosecutor's duty of fair dealing survive a guilty plea, People v. Pelchet, claim that prosecutor knew, and concealed from the grand jury, his knowledge that there was no evidence to support the indictment survives a guilty plea. Defendant's claim in this case rests on the purported exclusion of a witness, the substance of whose testimony was contained in an affidavit provided to the courts below. That proffered testimony was largely inadmissible and, in any event, would have inculpated him by establishing that he had a relationship with the complainant and had been in her presence in violation of an order of protection. The exclusion of such testimony before the grand jury does not present a constitutional defect implicating the integrity of the process, Hansen, and accordingly the claimed violation in this case did not survive defendant's guilty plea. In light of defendant's forfeiture of this claim, his remaining contentions have been rendered academic. Order affirmed, in a memorandum. Chief Judge DeFiore and Judges Stein, Garcia, Wilson and Feynman concur. Judge Rivera concurs in result in an opinion in which Judge Fahey concurs.
Decision podcasts by the New York Prosecutors Training Institute are made possible by VoicePods. Convert your text to voice at voicepods.com. Read this decision at NYPT Law. www.nypti.org/law.